welcome. So before we get started, I just want to give you a few updates. We have some news coming out of Europe. It looks like the European Union is discussing and is amendable to opening up tourism in Europe this summer. The discussions are that they will be disposing with the quarantine requirements for those who have been fully vaccinated. So that's good news. We do not have the final word on that yet, but they're talking about it, so that's progress. That's when it comes to traveling. Now, when it comes to coming to the United States, it is a case-by-case basis. We are getting a lot of questions from people about tourist visas, for either their loved ones or just tourist visas in general, or non-immigrant visas. It depends. It depends on what country you are in. It depends whether the country you're in is under the continued travel ban that is still in effect. It depends if the embassy in your home country has resumed regular processing of the visas. Now, as I mentioned before, the priority, of course, is for immediate relatives of United States citizens and certain other categories, wives, children, spouses and children of permanent residents, and fiancé visas. Some embassies are already processing non-immigrant visas, both tourist and certain employment investment visas. However, there are a lot of different embassies who are only doing immigrant visas, meaning that once you have a visa, you come to the United States, you are considered to be a permanent resident. So things are happening, and I will continue to update you on that. In terms of immigration court, as you know, New Jersey, Newark Immigration Court is open. However, when I say open, it doesn't mean regular reopening. There's a lot of things that have changed and will continue to change. There was a big meeting on immigration court status yesterday. The immigration non-detained hearings in New York will open first week of July. Now, there are 3 immigration courts in New York at 26 Federal Plaza, across the street at 290 Broadway, and at 201 Varick Street. Now, 201 Varick Street used to be exclusively detained hearings, but now there are several judges sitting in Varick Street doing non-detained hearings. The court reopens in sort of like a limited capacity. We're going to try to move away from going in for masters. Anybody who's ever been to immigration court on a master knows that it's a lot of time, and sometimes a very short amount of conversation with judges and the government attorneys. So to the extent possible, a lot of things will be done on paper. It's still work. We still need to submit things. We still need to meet deadlines, not to avoid any negative consequences, but we might not actually physically have to be going to court. Another news is that New York Immigration Court said that they will be implementing and actually starting to use remote hearings by the end of 2021. So hopefully this all works out and will streamline a lot of our processes and will be great. Obviously, there's going to be some kinks to work out, but we're moving in the right direction. The official backlog of the immigration court is 1.3 million cases, right? So if you're waiting for a hearing for a long time, it is not personal to you. It is not because of us. It's not because the judge doesn't want to see you. It is just the sheer amount of cases that are backlogged. Another news is that both USCIS and Immigration Court will be adding staff in form of immigration judges and USCIS officers. So that should theoretically start moving things along. We already see the USCIS is processing faster and more cases. Citizenship, we already seeing some cases in under a year. We are getting a slew of interviews for green cards with waivers. Oath ceremonies are coming much faster. We had 2 people in Newark, New Jersey who actually had their citizenship interview and was sworn in the same day. So the anticipated changes are happening. I will continue to update you on it as we go every Thursday. Next exciting thing. Okay, what do we want to talk about? Waivers, 601 waivers. So 2 weeks ago, we talked about a scenario where a person has crossed the border, and we discussed 601A waiver. Today, I want to talk about a related but a different waiver. It's called a 601, inadmissibility ground. Now, in these videos, I try not to use a lot of language, a lot of legal language, because the purpose of this is just to make you understand how to get from where you are to, you know, a green card or citizenship, or whether there is a path and stuff. I'm not going to bore you with any legalese or lingo that you don't need to know. This is no reflection on my assessment of anybody's mental capabilities. This is just plain language. I'm just trying to tell you how things are. So, best way to do is on an example. There are circumstances where a person has come to the United States with a passport. The passport was fake. That's one scenario. Number 2, the passport was real, the visa was fake. The passport was real, the visa was real, the photograph was fake. Or, and this has been coming up a lot recently, when a person gets a visa, they, in their home country, a lot of the times they use like notarios or like legal assistants or like immigration services, and they go to these immigration services and they say, I want to go to United States, and they say, no problem, sign here, go to the interview, say ABCD, and you have your visa. A lot of people think that once they're in United States, you know, because they entered with an actual visa and then they marry somebody or they're getting their status, you know, another way, what happened at the embassy no longer counts. I'm here to tell you that it does in a big way. And we actually have quite a few people who are experiencing issues and are requiring a waiver because of that. So this is a fraud or misrepresentation. You have given to the immigration officials either a fake document or provided information that is not truthful or somehow misrepresented a fact about you, right? That makes you inadmissible, unable to get a green card. Fortunately, there is a waiver for that. That's the 601 waiver that we're talking about. That waiver doesn't make you go back to your embassy, right, or to your home country. The government acknowledges that you have entered through a port of entry. You were inspected by, your person was inspected by an immigration official. However, there's an issue with how you obtained the entry documents, the visa or the passport, or how you entered the information that you presented when entering the United States. So what happens, let's say you got married to a U.S. citizen and you put in your documents and you come to the interview, and the officer in the interview says, okay, your marriage is real, no issues here, you're definitely married, you have kids, whatever the case may be. I'm not doubting that. However, on your green card information, you said that this is your first marriage and you have one kid or don't have any kids. But immigration officer says, we have documents here from the embassy saying that at the time when you got your visa, you told them you were married back home and had 2 kids. Yes, they do have access to the Department of State documents. Yes, this has been pulled up, especially recently, because everything is electronic that has come into play. So in that case, the officer is not going to let you go any further because you violated an immigration law, or you can prove that you entered with the visa to the United States. You have the visa, you have the I-94 card, you have the passport, but the name on it is not yours, or the picture is not yours, or the passport is not yours, right? Or you provided some document, other document that is not real. The way to overcome this is by going to the U.S. government saying, I'm sorry, I know I did this. I acknowledge it. Again, every case is different. I'm generalizing. So you say to them, yes, this has happened. However, I have a qualifying relative who will suffer extreme hardship if I were to go back to my home country and we were to separate, or if that relative was forced to follow me back home. So let's break that down. First of all, who are the qualifying relatives? The qualifying relatives are spouses who are green card holders or U.S. citizens, or parents who are green card holders or U.S. citizens. For the purposes of a waiver, it makes no difference whether the qualifying relative is a green card holder or a citizen. How do we show hardship? There are many different ways. There is no one single definition of hardship. This is where, we have detailed conversations with our clients, and sometimes things that may not appear so end up playing a big role in your case. If your qualifying relative, your spouse or your parents, depends on you financially, because there are small kids involved, or because they're unable, to work themselves, medical issues. For example, we have a client whose wife has asthma, and it is triggered by a very hot climate. And the wife was born here, but if she were to follow that person to where he's from, that climate would most certainly trigger her asthma. Here in the States, she has a doctor who she has been seeing for over a decade. She has the dosage of the medication, the type of medication. If she has an outbreak, she knows, what hospital to go. She has a support system and a network, not to mention insurance, that allows her to, if necessary, obtain a life-saving medication, right? That is just an example of that. Also, there is, emotional trauma. There is no, again, single definition of it. Things can be put together as a puzzle. Financial can go into medical can go into emotional, psychological, and so on and so forth. It is also important to get the background story. For example, if a person was running away from a severe abuse, right? and then they have come here and they've experienced in their past relationship severe trauma, but their new spouse has provided for them a healing component. They were able to stabilize and normalize the life of that person. You know, having them separated will cause more trauma. It can lead to sometimes very dangerous, fatal outcomes. So there is more than one way to approach the situation, and most of the time we don't just concentrate on one aspect of it. We kind of build up an entire picture touching on all the aspects, right? We have had cases where the spouse, the qualifying relative, was not able to work because they suffered a severe form of depression, when there were days and weeks when they were not even able to get from the bed. The reason they suffered that is because there was trauma that they've experienced as a little child, and then the normalizing factor in their life, the thing that allowed them to continue living and functioning and stuff like that, was the spouse. So it wasn't just the financial support that the spouse provided, it was a lot, more than that. So these waivers are very creative in a way that you cannot look at them in just a one dimension. They're multi-dimensional, and everybody's story is different. And we have had cases where people were not even living in the same households, but we were able to get the waivers approved because there were very particular circumstances in their case, right? There's no one size fits all. It has to be a personalized approach to do the waiver, right? So the most typical scenario is, let's say there was a fake document that would use to enter the United States. You have an entry, but you have this immigration violation. So then we would prepare the entire package and we would submit it to the USCIS, and then when you go to the interview, you essentially are having 3 interviews: the marriage, to make sure that your marriage is legitimate, and then the waiver. The officer is allowed to ask questions about that, and then finally the green card itself. Now, what a lot of people need to understand is that when we talked about when people have crossed the border and they need the 601A waiver and to consular process through back home, the very important thing to understand is that that has to be the only thing essentially that was wrong in their journey to the United States. If that person have gotten the 601A waiver, but then it turns out that they have in the past have also used a fake document or a fraudulent document and somehow misrepresented themselves, if they were to enter, go to the embassy, and that fact would come along, the immigration officer, the embassy, would deny their immigrant visa, cancel their 601A, and make the person apply for another waiver before letting that back in. And that can, of course, delay the processing of your immigrant visa for as long as a few years. That is only one type of a case where the 601 waiver is being used. We have had circumstances where the person was already outside of the U.S. They were not in the U.S. And they went to the embassy, and the embassy said, no, we want you to submit a waiver because we have found that, before that, you lied about your date of birth, or you lied about the use of the name that you've had, or other issues. And then a person has to get the waiver while remaining outside of the US before they can reprocess their immigrant visa, right? What else is the circumstances? The other one that is a very, very common one is, let's say you come to the US and you have been here for more than a year. If you come, you've been here for more than a year, and then you leave the US, at that point you have already triggered an unlawful presence bar. And if you have left and you've been here for more than a year, you cannot then return until you've stayed outside of the US for 10 years, right? So it sounds, a decade is a very long time. However, you can return earlier if you apply and obtain successfully the 601 waiver. The requirements are the same. You have to show that your qualifying relative in the US would experience hardship if you were not able to return, earlier than 10 years, and that qualifying relative cannot come and live with you in your home country. That's another important aspect that people forget about. There's no assumption that you have to live in the United States. You have to show the immigration why your loved one, your parent, or your spouse cannot just move to the country where you are. And as I gave you the example before, it could be a multifaceted answer. They may hold a type of license in the US that allows them to provide and have a better standard of living, that they went to school to obtain. That's one of the things. They may not speak the language of your home country, which would severely decrease their chances of being able to find a job and function in the society. There may be medical issues for which would prohibit them from moving to that country for either environmental reasons or lack of medicine. All of these factors do not have to be one in and of itself. They can be stacked up, right? Another note that I'm going to mention before I sign off is that even though the children by themselves are not qualifying relatives, that's just the way the law is, they can play a big factor in drafting the waiver. There are many different ways in which kids can definitely be a contributing factor in establishing hardship to a qualifying relative. It depends. Just if you come to me and you say, I have these two great, kids with my wife or my husband, and they are US citizens and they're entitled to continue living in the US, and therefore my spouse or I am entitled to continue living here with them, that in of itself is not enough. The US government is not going to consider that as a hardship. Your waiver is not going to go through. But there are other ways to weave, the kids into the waiver and into the hardship to the qualifying relative. Okay? We do a lot of waivers. We have a very personalized approach to each one. We listen to your story. We gather the facts. Sometimes more facts come out as we start working with you and you build the rapport. And every waiver does take time because we try to document it the best way possible. And we give you documents. We work with you to prepare the affidavits, to gather everything and, put it together to present a well-rounded picture to the immigration officials. Okay? So that's a very interesting, very creative fields of immigration law. I hope this has been informative for you. If you have any questions, if you'd like me to go back and touch or expand on something in this area, I definitely can. If not, send me your requests for topics, and I will address them next Thursday. For now, I hope everybody enjoys the weather. This is going to be a great summer. Restrictions are being lifted. All very, very exciting things. As always, you can reach out by email, text, or phone, and we will be happy to schedule some time to speak to us. Thank you. Have a great weekend. Have a great week. See you next week.